Hello and welcome back to these legal studies revision videos. Today we will be going over the key concepts in criminal justice system. So these include summary and indictable offences, so the different types of criminal offences, burden of proof, who has that in a case and what does that mean, the standard of proof in a criminal case, and the presumption of innocence as well. So first of all, we're going to go through the different types of crimes. So there are essentially two different types of criminal offences in the Victorian criminal justice system, and then a third sort of different type that we'll talk about as well. The first type of criminal offence they're called summary offences, and what that means is basically they're not the most serious types of crimes. They're quite minor. They're still crimes, so they're still considered serious under the law, but these are things, for example, like assault or something like speeding, for example. So obviously speeding is a lot less serious than something like murder, so that's why it's considered a summary offence. So these types of summary offences, these are just examples, but there's lots of other things. They will be resolved in the magistrate's court, which is at the bottom of the Victorian court hierarchy. So instead of having a case heard by a judge and a jury, it will just be heard by a single magistrate instead. So that's where the summary offences will be heard, and if you want to have a look at what these offences are, it's good to know that they do come from the Summary Offences Act. So that's the actual piece of legislation that Parliament made, and that is where they come from. So that's the first type of offence. The second type are indictable offences. This is the opposite. These are much more serious types of crimes, things like murder, stalking, maybe things like arson that are much more serious and normally will have more serious consequences. So those are indictable offences. So instead of being heard in the magistrate's court, which would be for a summary offence, indictable offences will be heard in the higher court, so the county, in the county or Supreme Court, and instead of being heard by a magistrate, it will be heard by a judge and a jury. All indictable offences will have a judge and a jury in their trial. These aren't listed in the Summary Offences Act, that's only for summary offences. Instead, indictable offences are listed in the Crimes Act instead. So those are the main differences between them. So an easy way to remember is just summary are the less serious crimes, indictable are the more serious crimes, but it's good to know these extra details, where they come from, where will the case be heard, what are some examples, to make sure you have enough information to fill up an answer in a SAC or in the exam. The third type of offence is a little bit different. So these are called indictable offences tried summarily. So that might sound really confusing. Basically what it is a type of indictable offence that isn't right up the top on sort of like the scale of seriousness. So up the top would be something like murder and terrorism, things that, will never be excusable in society and need to make sure that people are punished for it. But you get down towards the bottom near the summary offences, and there's got to be a line somewhere, what's a summary and what's an indictable offence. So at this line where it's an indictable offence, but it's not super, super serious, what can happen is that the accused can apply to the courts to have their offence heard instead of an indictable offence. It can be heard as a summary offence instead. So that's what that means, to be an indictable offence, but it might be tried summarily. So if it was tried summarily, that means it would be heard in the magistrate's court instead of in the county or Supreme Court. And that's a good thing because the magistrate's court has a limit on the punishments they can give out to people, so you're more likely to have a sort of a better outcome if you're the accused. You'll be spending less time in prison and things like that. So remember, this isn't for the most serious offences, things like murder, only those sort of in the middle types of offences. But they have to apply to the court, and if the court thinks it's not appropriate, they won't accept their application. So these are three types of offences that you need to know for this first area study. Okay, next we're going to be going through the differences between the burden and standard of proof. What does that mean? And also apply it to criminal law specifically. This concept will come up again when we go through the civil law in area study 2, but there's differences between criminal and civil law. So I'll give you a general definition, but then we'll only be looking at criminal law today because that's for this first area of study. Okay, so the burden of proof is a type of party in a criminal case, in any case at all, and it's the party in the case during the trial that has the responsibility to prove the facts of the case and fulfill the standard of proof. So that's this first sentence here is the more general definition. Specifically in a criminal case, this burden of proof lies with the prosecution. So remember in the last video, we talked about the prosecution and the accused are the two types of parties in a criminal case. The prosecution is the party that is responsible to prove the facts of the case and the standard of proof. So I'm going to explain the standard of proof, but then I'm going to come back and link them together and hopefully it will make a little bit more sense. So the standard of proof is the level, or sort of the strength needed of the evidence that needs to be proved. So in a criminal case, the standard of proof is beyond reasonable doubt. So what that means, like I said, the burden of proof has to fulfill the standard of proof. So the job of the prosecution in a criminal case is to prove that the accused is guilty of whatever crime they've been charged with, but not just that they're guilty, you know, that it's 50-50, that they're probably in the wrong, they've probably committed the crime, but they have to prove that beyond reasonable doubt. So what that means is that the jury, because they're the ones that gives a verdict of guilty or not guilty, the jury has to be so confident in their decision that the accused is guilty, they basically have no doubt at all. So what this means is that the jury has to be completely confident that the accused is guilty, and they can't have second doubts about, well, maybe they didn't, or maybe they were at another place or something like that. They can't have that doubt and then give a guilty verdict. To give a guilty verdict, they have to be pretty much 100% sure that they're guilty. So that's what that means, beyond reasonable doubt. So linking these together, it's the prosecution has the burden of proof to fulfill the standard of proof and prove that they're guilty. So the prosecution presents evidence to prove that the accused is guilty, but it doesn't go the other way around. So if you're charged with murder, you technically don't have to prove that you're innocent. It's the other way around. The prosecution just has to prove that you're guilty, but you can give evidence to defend yourself instead. Okay, now we're going to go through the next concept, which is the presumption of innocence. So the presumption of innocence essentially means that, thinking back to the standard of proof, that it's really, really high beyond reasonable doubt. It means that if you're charged with a crime, you will be treated by the justice system as an innocent person until that standard of proof, beyond reasonable doubt, has been satisfied. So this means that even if you're charged with murder, you can't be treated as a murderer during your case. So this means that you will most likely be granted bail, because by giving bail to someone, which means they're out and free, living their normal life during the trial, you're treating them as innocent. If you knew that they murdered them and you weren't treating them as innocent, you wouldn't be letting this dangerous person free on the street. So bail will be granted unless there's reason to believe that you are a danger to society, maybe of prior convictions or dangerous history or something like that. So that's an example that how the presumption of innocence is upheld. So you're treated as innocent until proven otherwise. Here are some other examples of how the presumption of innocence is upheld. So we've talked about granting bail, but other things like the right to silence. Just because you're silent and you're not defending yourself doesn't mean you're guilty, because remember, you don't have to prove that you're innocent. It's the other way around. The prosecution needs to prove that you're guilty instead. Lots of other examples here. Feel free to pause and read through them as well. Okay, so this is a case study you'll probably learn in class about a few years ago, I think 2017, with the Burke Street Mall attack, where a few people died in Victoria. And this is a good example about the bail system, presumption of innocence, because the person charged with this crime was actually out on bail at the time. So he was treated as innocent by being granted bail. That's why he was out free in society. But it shows that the bail system isn't actually perfect, because he broke his bail, because obviously when you're on bail, you're not allowed to commit any other crimes, but he ended up killing, I think, 4 people. So this is a good example to say that the bail system is not great, and maybe think about the principles of justice as well. You know, justice wasn't achieved here, and I think the justice system needed to do a better job than it did here. So maybe have a think about how you could apply principles of justice to here as well. Okay, so that's it for today's video. Here are some key definitions if you think you want to do any revision of the things we've gone over here. These are some concepts that you want to make sure you can define and explain, write about all of that sort of thing. So maybe take some notes on these things, but come back, watch the video if you ever need some extra revision as well. So I'll be back soon with some more videos, but make sure to like, comment any suggestions, requests, anything like that you might have. Otherwise, I hope you have a lovely day.